Good day everyone, especially to you, Dr. Ria Kibir. Again, I'm Hanna Perocho from BSHM3A. So in this video, I'm gonna discuss about the chapter 5 that talks about the law on sales, agency, and credit transactions. So, according to Elizabeth Weintraub, agents should be ideally work for the best interest of the client. Because of the trust given them, agents initiate actions, administer, and collect on behalf of the client. So let's go for the learning objectives. We have here to describe and explain the nature of sales transactions, identify the functions of and operation of agencies in the industry, and also identify ways of handling credit transactions. So for the topic outline, the first one is laws on sales, characteristics of a contract of sale, requisites of a contract of sale, effect of loss of a object in a contract of sale, sale of a personal property payable in installments, pacto de retro sale or the conventional redemption, obligations of the vendor, obligations of the vendee, liability of the principal and the agent, simple loan or mutuum, and lastly, the pactum commissurium. So for the introduction, in the tourism, travel, and hospitality industry, businesses and customers often make agreements through contracts, which are legal promises between two or more parties. One of the most common contracts in this industry is a contract of sale, where a seller transfers goods or services to a buyer in exchange for payment. However, the problems can arise if one party fails to fulfill their part of the agreement, leading to disputes or breaches of contract. Understanding the law on sales helps businesses and customers know their rights and responsibilities, especially in different sales transactions, including what to do if there is a disagreement. So in this presentation, it will explain the different types of sales transactions that may occur under the industry and the legal remedies available when issues arise. By learning about these laws, individuals and businesses can make informed decisions, protect their interests, and avoid legal problems in their transactions. So let's go to the law on sales. So according to Article 1458, by the contract of sale, one of the contracting parties obligates himself to transfer ownership of and to deliver the determinate thing, and other to pay therefor a price certain in money or its equivalent. A contract of sale may be absolute or conditional. So in this article, it explains that a contract of sale is an agreement where one person agrees to transfer the ownership of an item to another person, and in exchange, the second person agrees to pay a certain price, which can be money or something equivalent to money. The sale can either be absolute, where the ownership is transferred immediately, or conditional, where ownership is transferred only after certain conditions are met. So for the definition of the contract of sale, according to Article 1458, for the legal definition, a contract of sale is an agreement where one party transfers ownership of a determinate thing to another in exchange for a certain price in money or its equivalent. For the key elements, the transfer of ownership, the seller gives a price to the item, delivery of a determinate thing, and also for the payment of price, where the buyer must pay in money or equivalent. For the types of sale, we have the absolute sale and the conditional sale, where in the absolute sale, ownership transfer immediately upon agreement, and for the conditional sale, transfer happens after certain conditions are met. So let's go for the characteristics of a contract of sale. We have the consensual, bilateral, principal, onerous, commutative, nominate, transmissive of ownership. The consensual is perfected by mere consent of both parties. Bilateral is where both buyer and seller have obligations. Principal is it can exist on its own without relying on another contract. The fourth one is the onerous, where each party gives something of value, money for goods. The fifth one is the commutative, where the value exchange is generally equal. Nominate, where specifically identified as sale under the Civil Code. And lastly, the transmissive of ownership, where ownership is legally transferred from seller to buyer. So for the requisites of a contract of sale, the first one is the consent, where both parties must agree without coercion. So in the consent, there are certain individuals are qualified to enter into a contract, and these are the husband and wife, guardians, agents, executors and administrators, public officers and employees, judges and justices, other persons that would be disqualified by laws. So for the object, the subject of the sale must be specific and existing. The cost and consideration, the price must be certain and paid in money or equivalent. So for the effect of loss of the object in a contract of sale, Article 1480 shows that any injury to or benefit from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery shall be governed by Articles 1262. Article 1262 shows that an obligation which consists in the delivery of a determined thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. And lastly, the Article 1496. The ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the way specified in Article 1497 to 1501 or in any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. So for the discussion of these laws, if the thing is lost before perfection of the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res spiritu domino, or it is the owner of the thing who bears the consequences of the law. And if the contract is not yet completed, the seller must deal with the loss. And also, if the thing is lost at the time of the perfection of the contract shall be considered without any effect. The legal effect is the same as the object is lost before perfection of the contract of sale. If the loss happens when the contract is made, it has the same result as if the contract was never made. And also, if the thing is lost after delivery, the buyer bears the risk of loss since delivery transfers ownership following the principles of res spiritu domino, and once the buyer owns the item, they must take care of it, including of if it is lost. And the last one is if the thing is lost after perfection but before delivery. The seller bears the risk of loss since there is no delivery yet, hence no transfer of ownership to the buyer. This is considered just and equitable, being more in conformity with the principle of res spiritu domino. In this case, the buyer may demand the return of the price in case payment has been made. This rule will apply even if the thing is lost through the fortuitous event or even without the fault of the debtor. If the seller can't deliver the item, the buyer should get back the money they've paid, since both the delivery and the payment depend on each other. So let's go to the sale of personal property payable in installments. Article 1484. In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies, and these are exact fulfillment of the obligation should the vendee fail to pay, cancel the sale where should the vendee's failure to pay cover 2 or more installments, foreclose the chattel mortgage on a thing sold if one has been constituted, should the vendee's failure to pay cover 2 or more installments. In this case, he or she shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. So for the discussion of the law of this article, in order for the above provision to apply, the following requisites must concur. Contract must be of sale or absolute sale, not a contract to sell or a contract of loan, or a pacto de retro transaction where the redemption is effected in installments. Second one is what is solid is personal property or the not real property. The third one, the sale must be on an installment plan. It must contain at least 3 installments. If the sale is for cash or on straight terms, here after an initial payment, the balance is paid in its totality at the time specified. Article 1484 does not apply. So let's go for the double sale. According to Article 1544, If the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession in good faith if it should be movable property. For movable property, the person should first takes possession in good faith gets ownership. Should it be immovable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. For immovable property, the person who first registers the sale of the registry property in good faith gets ownership. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof to the person who presents the oldest title, provided there is good faith. If neither of the above happens, ownership goes to the person who has the oldest legal title, as long as they are acting in good faith. So for the discussion of this law, the above provision pertains to the same property which has been sold to different buyers or vendees. In case an immovable property covered under the torrent's title is sold to different vendees, the one who is the first registrant in good faith at the registry of deeds where the property is located shall be preferred. So for the pacto de retro sale or this conventional redemption, Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulation which may have been agreed upon. So this explains that in a pacto de retro sale, the seller has the right to buy back the property sold under agreed terms, which includes following specific laws. And this type of sale allows the seller to reclaim the property if they choose within a certain time frame. And for the discussion of the law, as between an absolute sale and a sale with the right to repurchase, no difference exists except that in the latter, the ownership of the purchaser is subject to the resolutory condition that the vendor exercises his right to repurchase within time agreed upon. And for the obligations of the vendor, Article 1495, the vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sale. The seller must make sure the buyer gets the item and legally owns it. Plus, they have to make sure that the item is as promised. And in Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. It is the moment the item is given to the buyer and they will officially own it. And in the Article 1497, the thing sold shall be understood as delivered when it is placed in the control and possession of the vendee. And when the buyer gets control of the item, it is legally considered delivered, even if the item is physically still with the buyer. Under these provisions, the vendor has three main obligations. The first one is to deliver the thing sold, to transfer ownership, and also to provide warranty. So for the warranty in case of eviction, if the buyer loses ownership of the item because someone else has a legal right to it, this is called eviction. A vendor must protect the buyer from eviction, meaning the buyer should not lose ownership due to prior claims. This applies if the buyer is deprived of ownership by final court judgment, the judgment is based on prior rights or vendor-related actions, the vendor was notified of the legal case, and if the eviction occurs, the vendor must refund the purchase price at the time of eviction, return lost income and fruits of the property, cover litigation costs, reimburse contract expenses, and also pay damages if bad faith is proven. And for the warranty against hidden defects or the redhibitory, a hidden defect is one that exists at the time of sale, is unknown to the buyer, and also makes the item unusable or significantly reduces its value. The buyer has two options. The first one is action redhibitoria or the cancel the contract and return the item. Also, the second one is the action quanti minoris or keep the item but demand a price reduction. And for the prescription period, general hidden defects claim 6 months from delivery, and for the animal defects claim 40 days from delivery. Understanding these legal principles helps protect both vendors and buyers by ensuring fair transactions and clear expectation in sales contracts. So for the obligations of the vendee, Article 1582, the vendee is bound to accept delivery and pay the price of the thing sold at the time and place stipulated in the contract. So for the discussion of the law, actions for breach of contract of sale, extrajudicial remedies. When it comes to buyer, the buyer need not pay unless there is delivery. The buyer may reject improper deliveries. The buyer may also suspend payment if he is disturbed in the possession or ownership of the thing or has reasonable grounds to fear such disturbance. And as of for the seller, vendor is not bound to deliver the thing sold if the vendee has not paid the price. Installment sales or the Racto and Maceda law. For the judicial remedies, as of the buyer, damages for breach of contract, and of the seller, recovery of the price, damages in case of bad faith. So in this section, it explains that the buyer's and seller's action when a contract is not followed properly. For the buyer, they don't have to pay until the item is delivered, can reject wrong deliveries, and may also stop payment if there is a threat to the item's ownership. And for the seller, they don't have to deliver the item if the buyer hasn't paid. And installment sales are covered by special laws. If there's a breach, the buyer can demand damages, and the seller can recover payment or ask for damages if there's a bad faith. And this is about the actions both sides can take if one doesn't fulfill their side of the contract. So let's go for the law on agency. Article 1868, by the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. So for the discussion of the law, in simple terms, an agency is a legal relationship where one party or the agent acts on behalf of another or the principal with their consent. A contract of agency is a relation in which one person, the agent, acts on behalf of another with the authority of the latter, the principal. It is a fiduciary or relation which results from the manifestation of consent by one person that another shall act on the former's behalf and subject to his statute, with consent by the other so to act. The acts of the agent will be binding on his principal. This is when someone is authorized to do things for another person, and the agent's actions are considered to be principal's actions. So for the concept of an independent contractor, the hotel and hospitality industry often enters into contracts with cooperatives, associations, and associations that provide janitorial, security, and managerial services. This practice helps businesses reduce costs associated with direct employee wages. However, it is important to understand the distinction between independent contracting and labor-only contracting to ensure compliance with labor laws. And for the independent contractors, it operates on their own, using their own methods, and are responsible for their employees' wages and benefits. For the labor-only contractors, on the other hand, these are considered agents of the employer, making the employer responsible for the workers. And this explains the difference between independent contractors and those who work under the employer's control. So for the qualifications of an independent contractor, to qualify as an independent contractor, a cooperative or association must meet the following requirements. These are the substantial capital or investment, which includes capital stocks and subscribed capitalization or for corporations, and for the ownership of tools, equipments, machinery, and work premises used in the service. Work performed must not be directly related to the main business of the employer. The contractor must exercise the right to control over how its employees perform the work. So this means that independent contractors need to have their own resources and manage their work themselves. So for the liability of the principal and the agent, according to Article 1883, if an agent acts in his own name, the principal has no right of action against the person with whom the agent has contracted. Neither have such persons against the principal. And this explains that when an agent acts for someone else, if they act outside the allowed limits, they alone are responsible for what happens. And the discussion of this law is that In such case, the agent is one directly bound in a favor of the person with whom he has contracted, and as if the transaction were his own, except when the contract involved things belonging to the principal. When an agent transacts business in his own name, it shall not be necessary for him to state the name of the principal, and he shall be directly liable as if the business were for his own account to the persons with whom he transacts the same. Moreover, an agent is personally liable for acts beyond the scope of his authority, for acts in violation of the terms of the written authority. When it is clear that the agent is acting only in behalf of disclosed principal, the agent cannot be held personally liable on the contract entered into in such manner. So let's go to the credit transactions. Article 1933. By a contract of loan, one of the parties delivers to another either something not consumable so that the latter may use the same for a certain time and return it, in which case the contract is called comodatum, or money or other consumable thing, upon the condition that the same amount of the same kind and quality shall be paid, in which case the contract is simply called loan or motum. Comodatum is essentially gratuitous. Simply loan may be gratuitous or with stipulation to pay interest. So for the discussion of the law, Article 1933 of the Civil Code defined a contract of loan as an agreement where one party delivers something to another under specific condition, and these are the comodatum and the simple loan or the mutuum. Comodatum is a loan for use where the borrower must return the exact property lent. It is always gratuitous or the free of charge, while a simple loan or the mutuum is a transaction where money or other consumable items are lent, with the borrowers agreeing to return the same amount of the same kind and quality, and this type of loan may be either gratuitous or with an interest stipulation, and this explains the two types of loans and how interest is applied. So for the simple loan or mutuum, Article 1956, no interest shall be due unless it has been expressly stipulated in writing. And this means interest on loans must be agreed upon in writing, and the loan is just the transfer of goods or money with a return of the same amount. So for the discussion of the law, Article 1956 of the Civil Code of the Philippines states that no interest shall be due unless it has been expressly stipulated in writing. This means that for a loan contract to have an interest charge, the agreement must clearly state it in writing. Otherwise, the lender cannot demand interest from the borrower. A simple loan or mutuum is a contract in which one party or the lender delivers money or another consumable item to another party or the borrower, who agrees to return the same amount or quantity after a certain period. And this type of contract is commonly used in financial transactions, particularly in lending agreements between individuals or businesses. So for the nature of bank deposits, according to Article 1980 of the Civil Code of the Philippines, deposits of money in banks, whether fixed, savings, or current, are considered a simple loan or mutuum. This means that when a person deposits money in a bank, ownership of the money transfers to the bank, and the bank becomes the debtor while the depositor becomes the creditor. The depositor has the right to demand repayment according to the agreed terms, such as withdrawal or maturity of a time deposit. Since the debtor or the creditor relationship exists between banks and depositors, compensations may occur. This means that if a depositor has a loan obligation with the same bank, the bank has the right to deduct or offset the debt from the depositor's account. However, this action must be done following banking regulations and legal provisions in order to protect the rights of the depositor. This explains that how your deposit in the bank is treated as a loan to the bank, and the bank can use it to pay your debt with them. And so let's go for the real estate mortgage or the chattel mortgage. Loans are often secured by valuable properties, which may be either movable, like personal property, or immovable, or the real property. And these two common types of security agreements used for loans are real estate mortgage and chattel mortgages. And these legal agreements ensure that the lender has a form of security in case the borrower fails to fulfill their financial obligation. Real estate mortgage is an accessory contract where a debtor pledges real property or real rights as a security for a loan. If the borrower fails to repay the debts as agreed, the lender has the right to foreclose the mortgage property and sell it to recover the loan amount. And here's the essential requisites of a real estate mortgage include: the mortgage must be established to secure the performance of a principal obligation. The mortgator or the borrower must be absolute owner of the property being mortgaged. The mortgator must also have free disposal of the property, or if not, they must be legally authorized to mortgage it. And if the borrower defaults on the loan, the property can be sold to satisfy the outstanding obligation. And the subject of the contract must be immovable property or real rights over immovable property. So for the chattel mortgage, a chattel mortgage is a contract where personal property is used as collateral for a loan and is recorded in the chattel mortgage register. The main difference between a chattel mortgage and a pledge is that in a pledge, the collateral is physically delivered to the lender or a third party, whereas in a chattel mortgage, the property remains the borrower but is registered as security for the loan. And this registration ensures that if the borrower fails to repay, the lender has a legal claim on the property. So let's go for the last one, the pactum commissorium. In Article 2088, the creditor cannot appropriate the things given by way of pledge or mortgage or dispose of them. Any stipulation to the contrary is null and void. And for the discussion of this law, pactum commissorium is defined as a stipulation giving power to the creditor to automatically appropriate the thing given as security. If the principal obligation is not fulfilled without any formality, such as foreclosure proceeding and public sale, this rule says that even if the borrower defaults, the creditor cannot just take property without going through a legal process, like selling it in court. Any agreements that allows the creditor to take the property without this formal process is considered illegal and invalid. So let's go for the last one, the conclusion. The law on sales, agency, and credit transactions ensure fair business practices by defining the rights and obligations of buyers, sellers, agents, and creditors. In the tourism and hospitality industry, these laws are essential in managing hotel bookings, travel agency contracts, and restaurant transactions, ensuring clear agreements and consumer protection. Agency laws regulate tour, guides, and hotel representatives, while credit transactions enable tourists to book services through credit cards or installment plans. By following these legal principles, businesses in tourism and hospitality can operate smoothly, build customer trust, and promote economic growth. And that's all for my report about the Chapter 5 that talks about the laws on sales, agency, and credit transactions. Thank you for listening, and goodbye.